Greetings. When I left you in the last mini lecture, I had finished up the overviews and had started this notion of jurisdiction. Keep in mind that jurisdiction is the authority of a court to hear and decide certain cases. And so when there is a crime, we have to make sure that that crime goes to the appropriate court. I mentioned in the last mini lecture that there are state courts and there are federal courts. There are state crimes and federal crimes. And that part of jurisdiction I discussed in the last lecture. This lecture, I'm going to turn the discussion from the familiar state versus federal crimes to two types of jurisdiction that most of you are perhaps not familiar with. So the first type of jurisdiction that I want to talk about is original jurisdiction, right? The word original means the first, if it's the original. And so when we talk about a court having original jurisdiction, this is the first court to hear a case. It is the first court to hear a controversy. These courts are usually not called courts of original jurisdiction, although that's the technical name for them. Usually we refer to these courts as trial courts. These courts are interested in, quote, the facts, and I have that in quotation marks, and I'll explain later in the lecture why I have the two words, the facts, in quotation marks. And they render a decision or a verdict. So at the state level, the primary trial courts are our superior courts, as I mentioned in the last mini lecture. The trial courts at the state level, here in Merced County, for example, is the Merced Superior Court. It is in downtown Merced. It is a trial court. The primary trial court in Stanislaus County, which is where Turlock is the Superior Court in Modesto. So the trial courts for those counties are in those towns. It's probably a little less than that, but less than 1 out of 10 cases that is heard in a trial court is appealed to the court above it. They're called appellate courts. By definition, if an appellate court is listening to a case on appeal, they're often called review courts. These courts are not particularly interested in the facts of a case. They're interested in the application of the law. Was there an error in terms of how the trial court conducted the trial? Was there a problem with jury instructions? Did a judge not handle the presentation of evidence correctly? Was there an error in the application of a constitutional provision, for example? So I say that these courts are interested in the constitutional claim. Others say application of the law. I think either work just fine. Now let me illustrate original and appellate jurisdiction with my favorite Supreme Court case of my lifetime. Wow, I have it ranked first. I told you I like to rank things. So this case occurred when I was a young child. It is one of the few really good victories for my people. And my people are the poor. You guys know I grew up incredibly poor. So at one time in our country, the notion of whether a poor person was entitled to a public defender was an example of American federalism. So, for example, when I was born in 1958, if you were poor and you couldn't afford an attorney, if you lived in a western state like California, you got a public defender. You were given legal counsel, which, of course, in every state today, if you're poor and you cannot afford an attorney, one's provided for you. But not when I was born. When I was born, the states got to decide whether the poor were given legal counsel or not. And in most southern states, if you were poor and you couldn't afford an attorney, you were forced to defend yourself in court against a professional prosecutor. And so we have a very famous Supreme Court case called Gideon versus Wainwright. If you want to look it up, do a Google search and look into it. It occurred in 1963. The Supreme Court decided this case unanimously. And I'll go into this case in more detail later, but I want to use it right now to illustrate original and appellate jurisdiction. So Clarence Earl Gideon was accused of breaking into a pool hall, into a bar, stealing quarters out of the various machines, stealing a gallon of wine. Mr. Gideon, of course, was brought into trial court, into the local superior court. There was a jury. Mr. Gideon had not completed elementary school. There is some debate as to how much education Mr. Gideon had. The source that I consulted said that they guessed he had a third or fourth grade education. The highest I've ever seen is sixth grade. So let's go with the best case. Let's say that Mr. Gideon had a sixth grade education, although I don't believe that he had 6 years of education. So he was forced to defend himself in court against a professional prosecutor. Imagine that. A lot of the business of the court uses complex legal terminology. At times, there's even Latin phrases used. And imagine a man who had not even completed elementary school trying to defend himself in court against a professional prosecutor. As you might guess, Mr. Gideon had about as much chance of winning that case as a one-legged man in an ass-kicking contest. He was convicted based on, quote, the facts, and was sent to prison. Now, while he was in prison, he got some help. And Mr. Gideon was told to appeal his case to the Florida Court of Appeals because Florida had deprived him of a constitutional provision under the Sixth Amendment, which guaranteed legal counsel or lawyers for the poor. Florida argued that the Sixth Amendment only applied to the national government, and if Mr. Gideon were in federal court, he would be entitled to a public defender. But Florida was not under that same obligation. The Florida Court of Appeals ruled in favor of Florida. The case was then appealed to the Florida Supreme Court, where once again the state of Florida prevailed. The case was then appealed to the U.S. Supreme Court. Now, when this case was appealed to the U.S. Supreme Court, the Supreme Court was not interested in whether Mr. Gideon had committed this crime of breaking into this pool hall and bar and stealing the quarters, drinking the wine, stealing the wine, whatever the case may be. In fact, it really wasn't even Mr. Gideon that was on trial. It was the state of Florida. And in this case, the U.S. Supreme Court ruled that Florida had, in fact, deprived Clarence Earl Gideon of the right to counsel under the Sixth Amendment, and that all states had an obligation in providing the indigent, the poor, legal counsel. Now, don't be naive here. The Supreme Court did not say that all people are entitled to the same legal protection or equal protection. What the court said was that the indigent or the poor are at least entitled to rudimentary legal counsel. So Gideon's case went back to Florida Superior Court. He was retried. And a public defender was able to expose a very, very weak case. And Mr. Gideon was found not guilty. So the point of this is, did the facts really convict Clarence Earl Gideon? Not at all. What convicted Mr. Gideon was his ignorance, his inability to put up an adequate defense, to defend himself against the skills of a professional prosecutor. The reason that I bring this up is that today, 4 out of 5 people who go to court are represented by a public defender. The courts are overburdened. The public defenders have huge caseloads. And as a result, the public defenders are often not able to put up an adequate defense. And what most public defenders try to do is to plea bargain in order to ease their caseload. I saw one study, and I forgot the exact details about this, but in the state of Texas, it was estimated that the state of Texas spends over $2 million in prosecuting criminal defendants in death penalty cases. And the state of Texas spends less than $5,000 to defend them. Think about that. $2 million spent to prosecute and less than $5,000 to defend. You can probably guess that there's a lot of people who are not guilty because of the facts, but are found guilty because their defense was inadequate. And that has not been rectified by the courts. But here's why that is significant. There are about 80 million cases a year in the court system. I'll talk about this later. And what if the courts only get it wrong 1% of the time? They get it right 99% of the time, which is incredible to think that anything can achieve 99% accuracy. But let's assume, just for discussion purposes, that that's true. Well, that means there's 800,000 mistakes a year in the court system. If there's 80 million cases, and admittedly, 65 to 70 million of them are traffic court cases, but 99% accuracy means 800,000 mistakes. And if we're dealing with a mistake in a traffic case where somebody pays a $200 or $300 fine, it may not be the end of the world. But if those mistakes, and some of those mistakes, are in death penalty cases where someone's life is at risk, it's a true catastrophe. So that's jurisdiction. Let me give you an introduction to our next topic. How do presidents decide who to nominate for the Supreme Court? Some things are fairly obvious about this, obviously, that presidents are going to nominate people of their party. They're going to look for people who see the world the way they do. So let me just, in the minute and a half that's left, just go through the first of these criteria. The first is policy preferences. When I ask you on the exam, typically, what is the most important criteria for the nomination of a Supreme Court justice? It's policy preferences. Presidents want to nominate justices who view the world, or at least the law, the way that they do. Now, obviously, what issues are important depend on the president. So Bill Clinton wanted all of his nominees to uphold the landmark abortion case of Roe versus Wade. President Nixon, interestingly, given what happened to him, wanted his justices to give the police more power to investigate criminal behavior. In federalism, I mentioned earlier that Andrew Jackson was a states' rights guy, and one of the reasons that he nominated Chief Justice Taney was to invoke the 10th Amendment to protect the power of the states. As I mentioned earlier, usually presidents get what they want 80% of the time, but 20% of the time they don't. I will get into this presidential nomination process in more detail in the next mini lecture.